Yes, Mr. Bertram.
My lords and my lady, I understand that you may have been favored with some further emails.
Oh,
Oh dear, you haven't seen them yet.
hold on. Well, the office may have received them, but not
Yes.
yet got them to us. Let's just check. Are these more brightly coloured conveyance?
There are more pink and other coloured documents.
Good.
Right.
Yes, I think they must have caught the email transcription department at its lunch hour.
So if you don't have them, I'm going to, if with your leave, I'm going to go to the 1967 deed. Oh, my lord, I'm so sorry. I need to answer my lord's question. My lord asked me to identify the paragraph.
Oh, I think I found it.
I'm obliged, my lord.
Oh, yes.
Let's check.
55?
Yes, my lord, can we check?
55?
That's very...
Oh, that was not the number I was going to give you. So,
Oh, right.
I've got the...
Yeah, I got the email as well. Just as
right.
Yes.
Oh, yes, so have I. Just arrived. And what's this got in
Oh,
it?
wait a minute. So this is still A2, isn't it?
This is the 1967. No, it's not.
No. This is the partially signed version of A2. Doesn't have Mr. Stokes' signature on it.
Well, except it's May 82. Oh, no, it's prefixed to the agreement, right.
Anyway, yes,
We've got it.
we've got
We
it.
can say that.
Yes, my lord, yeah, you may be one step ahead of me because I haven't seen, I think there was a second, no, my lord, I was thinking about what I was about to tell you rather than looking at my email. I understand you've got 2 emails, I hope that's right. One of them has 2 survey plans next to it, and another has a third from 1967.
I think the third one is, we've got one at the moment that has one plan next to it.
If you scroll down, I think it
Yes.
is a second.
It's just,
That's the,
Oh, I see.
the one that
Yes, hold on.
came during the hearing.
yes.
Yes, you're right.
So it looks as if we've got A2 and A4.
No, I don't.
No.
No, my lord, I
Two
think
versions of A2.
you have 2 versions of A2.
Yes.
Oh,
You
I'm
do not
sorry.
have A4,
No, I'm sorry.
and I don't want to be despondent, but you might not get A4 at all.
Perhaps you, but rather than us speculating, perhaps one of you would be kind enough to tell us what we have now.
Yeah.
Well, I'd rather my friends tell me because they sent it to me,
Okay.
so I can confirm if I agree.
So I can help your lordships and your ladyship. The email that you've just received has 2 colour originals of the plan that was ended up being called Plan A2. The first one in that PDF of 2 pages is number 91705 at the top left.
Yeah.
That corresponds with the number at page 22 in the bundle. So this is the plan as was given to Walter Stokes for signing.
So it looks as though this is actually genuinely what we've been calling A2. It
Yes.
just doesn't have Walter Stokes' signature.
That's right, my lord, yes.
Walter Stokes' signature is added to this very document later
Yes,
on.
that's how it looks, yes, my lord.
Right.
The second page in that PDF is numbered at the top left 91704, implying it's Mr. Sylvester's previous plan, consecutive to 91705.
Yeah.
And that's the same plan that was sent to your lordships by email during the
Yeah.
morning hearing. And that's as earlier given to Walter Stokes. That's as much as we know about. So this is
Which was the one actually appended to the May 1982 agreement?
91705, once signed by Walter Stokes. If you look at page 22,
Right.
my lady, it says 91705 in top left.
That's interesting. The colouring is quite different.
The colouring. So this does look as though there is the right-of-way area is coloured brown, somewhat distinctly from the road. Is that a fair observation?
In 91705, my
Yeah.
lord, I find that hard to say.
All right.
I do say. I also remind myself and your
I've
lordship.
just got something which does look like the something coloured
the
in pink
second
and
one.
green. Yes.
Yes. Now that I think your lordships and your ladyship may have just received the colour copy from the deed from the registry of deeds itself of the plan attached to the 1967 deed. Because those our colleagues in Trinidad
Oh yes, because that refers
have been
to
working
Mrs.
hard on Lord
Stanhope.
Briggs's request to find that, and they went to the registry of deeds itself. So that was not part of the trial bundle. That's come straight from the registry. But it does show a colour copy of the 1967.
And that's the 1967 plan.
Yes.
In pink and green, as we hoped it would be. Yes.
Yes.
And can I just check on the one that we were just looking at, 90, I've forgotten the numbers now, but the one that was partly signed?
Yes.
Was that in the material before the court for the trial?
As far as we can see, no, my lord. Only the one that had all three signatures on it, which rather tends to imply that there were duplicate copies. Because if we have one that's
And
unsigned,
did the trial,
it's not the signed one.
No, did the trial, is there a version of 90705, 91705, with all the signatures on in colour? A, which exists, and B, was it before the trial judge?
Well, the answer to that may be in Mrs. Peake's oral submissions to the Court of Appeal at page 784, because she described what she had found, having seen that she had black and white copies. She, where are we? So 784 line 5, she confirms that the bundle has only black and white copies, and the documents filed in the High Court were only black and white copies. So it's not that there was an original colour version filed and then photocopied black and white. It's rather that the court only ever had black and white. So she went to check by herself also looking at the registry, as you can see at line 18, the registry of deeds. And I infer from what she's saying that she has seen the final version of 91705, but she's not prepared to say exactly how brown it was.
Right, but at all events, in answer to my
that help
question,
you,
did the trial judge have coloured versions? I think
No, she
she's
did
saying
not.
no.
She did not.
Nor the Court of Appeal, Judge.
Nor did the Court of Appeal. Although you'll see that when at line 12, Mrs. Peake complains that the witness was asked, do you see anything coloured brown? And Mr. Maharaj at line 21 gives his recollection that the witness was shown coloured plans. So we are left in a rather confused situation. Mr. Maharaj doesn't remember what was in the hand of the parties when the witnesses were being cross-examined.
Is it right to say that in 91705 there appears to be colouring through from what's been described as the larger parcel, and also, whether it's quite the same or not, into the smaller parcel?
In 91705.
91705, which is the one signed by the porters.
Yes.
There appears to be colouring in the smaller parcel and in the larger parcel.
Yes, and we would expect the larger to be coloured pink. What's very hard to tell, and what we've noticed, my lord, is that everybody's screen shows a slightly different colour.
Yeah. And
these are 40-year-old plans as well.
But the difference with the 91705 and 91704 is that the road is also coloured
In
brown.
704, yes.
And no one was saying that a right-of-way was being given over the road, presumably. But it's not really possible to see whether that's the case also in 91705. There we are.
I've just been told that your lordships and your ladyship can expect also from the registry of deeds a colour copy of A4. They've now found that in the registry. So that's going to come through by email as well. But it's, again, not was in the bundle, not was what was before the judge. It's straight from the registry.
thank you.
So, my lords and ladies, I'm going to do the best I can with that when it arrives. I was trying to answer my Lord Briggs's question, which is where in the judgment of the Court of Appeal. So, my lord is right. The Court of Appeal did refer to the suggestion that that Mr. Porter was not accurately or reliably described as an untruthful witness at paragraph 55. It also occurs in the context of paragraph 86.
86.
86.
Page.
Page 430 of the electronic bundle.
What was the first reference?
The first one is paragraph 55, which you'll find on page 420, my lady.
Subparagraph.
That's, sorry, did I say 85 a moment ago, my
You
lord?
said 430.
Yes.
86.
And I hope I said 86. I should have said 86.
Okay, following page, yeah.
Not at all, my lord. So, my lord, at 85, just for context, the Court of Appeal simply say that Mr. Porter's lack of recall and the inconsistency between the date of A4 and the date of the meeting at Celia's office did not necessarily mean he was an untruthful witness, which, of course, was the submission I made before the short adjournment. Paragraph 86. As to the contention that the parties agreed that because the Porters had already approached a financial institution to provide finance for the project, they could not cancel the agreement, I say this: it is more than likely that any such financing would have required that a mortgage be secured on both parties as security for the provision by the financial institution of the monies for the purchase price. The arrangements as put forward by the respondent would have been a fraud on the financial institution perpetrated by the parties. The respondent's evidence does not suggest that the solicitor was complicit. I find the respondent's account of this arrangement to be highly incredible. Right? And further, Mr. Porter's reason for the delay in executing the agreement is far more plausible and persuasive. Now, my lord,
What was Mr. Porter's reason for the delay in executing the agreement?
my lord, sorry, I apologize, my lady. Lady, you would recall before the short adjournment, you asked me that question in the context of the drainage plans.
Yeah.
And I was distinguishing his faulty recollection as to when it happened.
But now,
Oh, I'm sorry. No, I'm not answering the correct question. Lady, pose the question again. I'm so sorry.
what is the reason for the delay given by Mr. Porter,
Yes.
which the Court of Appeals say is far more plausible and persuasive?
The drainage plans.
Right, but
Explanation.
you've now abandoned that as the reason because you're now accepting that the drainage plan was put on the Plan A4 in April, not in August.
I am accepting that the document is probably reliable, but I am also accepting that Mr. Porter, doing the best he could, his recall was that it happened in August.
Yeah.
And I'm saying it's my submission before the short adjournment was simply this. It's entirely understandable that he might have been
Yes.
mistaken as to when something happened.
Yes, but
Yes.
it must still be the case that that can no longer be a plausible and persuasive reason for the delay. It may be that he's
Yes.
mistakenly said it was in August, but if it's now accepted in that it was in April, it's
My lady is right. I accept that.
can't be.
I apologize. My mind was on something else when I was answering my lady's question. But my Lord Briggs, at paragraph 87, so these are the paragraphs I found, there's a reference to the evidence of Mr. Pechenik and Mr. Rameshand, and then there's a comment at the beginning of paragraph 88. This is all on page 431, and this is what I had in my mind when I said it was unfair, where what the Court of Appeal observed was that, and I quote, none of these alleged admissions was put to Mr. Porter during cross-examination. So that to the extent that my learned friend relies upon so-called admissions made by Mr. Porter or in the presence of Mr. Stokes, and they are repeated by these witnesses, none of that was put to him in his cross-examination.
Yep.
And then there's paragraph 89, which, just to close off on that
Thank you.
topic.
Okay, sorry, just if you'll
My lord, I'm
give us a
sorry.
full reference, I think
Yes.
27.3 on page 412, one should probably just note as well, although that's heralding what's going to follow.
Yes, my lord, quite right. A fair and accurate summary. So, my lords, I was going to, first of all, take you to the 67 deed, although I hesitate because I have not yet seen the plan that has been provided.
Well, it does what it says on the tin in the sense that when you get a coloured plan, it is coloured pink and green.
Right. My Lord, I've got it.
Whereas the one in the bundle has pink and green written on those two parts.
My Lord, are we talking about the 67 deed now?
1967 deed?
Yes.
Yes.
Yes. Yes. So, my Lord, that's to be found, I believe, at page 70 of the electronic bundle.
Yeah.
And so the first point to be made about it is that there is no analysis by the lineage judge of that document. There's no consideration of it, at least none that I could find. If I'm mistaken, then someone will correct me in due course. So my respectful submission is that too, in addition to what I said before the short adjournment, that too is a basis for the Court of Appeal regarding itself as being entitled to interfere, to reconsider, and to give context and a more cogent analysis. But, my lords, if we focus our attention on page 71, my lords will see, so this is a deed between Miss Stanhope Lovell and Walter Stokes. If we go to the second recital, it identifies on that page the larger parcel of land, the 1 acre, 3 roods, and 4 purchase parcel, colored pink, described in the first part. And then if we go over the page, we have the second parcel of land described in the first 2 lines. Its measurement is given as 17 purchase. We know from the evidence in the case that's the same as 430 square meters. Or at least Google will tell us if we don't know. And it is described in brackets or in quotation marks as the right-of-way. And as my Lord Briggs reminded me a moment ago, it too is colored. So the larger parcel is colored pink, that's the recital, and the smaller parcel is colored green. And that's in the second part of the schedule. So that insofar as one is getting a clue as to how it is or why it is that the conveyancers may have gone awry, when the deed that is the subject of this appeal comes to be considered, one will see that, obviously, to the extent that this was used as a template, as the Court of Appeal found, the error occurred in the recital, i.e., in the omission of the 430-meter square parcel of land from the definition of lands. If we then go to the operative part of the deed, my lords and my lady will see line 4 under paragraph 1, after the words hereby conveys, to the purchaser, the hereditaments, and the right-of-way already described, together with the privileges, except and reserving unto the vendor in fee simple free rights and liberty, and so on. And then that description goes on. I'm not going to read it all out to you, but my lords and lady can see it for themselves. It's the right and liberty, therefore, to use the remainder of the adjoining property with or without horses, animal carts, etc., and to pass and repass, those are the operative words, along the right-of-way. So that, again, that's a foreshadowing of what we see in the deed, and when we come to look at it, as we will very, very shortly.
And just in a nutshell, what do you submit we should draw from this document in relation to the right-of-way?
I would summarize my submission by using the word consistency. So that what this document shows is the consistency of a concern, A, about a right-of-way, and B, insofar as the 1982 deed either sought to replicate or reproduce or even re-grant the right-of-way of necessity in accordance with conveyancing practice in Trinidad and Tobago, recourse must have been had to this title document. So that's how it works. In other words, I'm going to digress, my lord, and answer to my lord's question. Ordinarily, the following would be the process by which you would become the title holder to a piece of land. You would have an agreement, if you're a purchaser, with your vendor. You will ask your vendor for a copy of their deed of title. Yeah. And then you would take That document, together with the agreement, it might be drawn up informally, it might be drawn up by a real estate agent, or you might have asked your own lawyer to draft it up. Those were the two documents that would initiate, as it were, the process whereby, and I know there's been some exchanges about prudent conveyancers and sensible conveyancers, so the ordinary conveyancer, the ordinarily prudent conveyancer, would use those two documents as a starting point. And my lords, it's just as well for you to know two things, that the searches of the registry of the sort that my learned friends have been busy doing in Trinidad, those searches are carried out by persons who are clerks. They're not trained lawyers, they're not trained conveyancers. That's number one. And number two, as a matter of practice, similarly, certainly the first version of a draft deed of conveyance would be drawn up by a conveyancing clerk. Yes, vetted by a trained lawyer or conveyancer, but certainly in conveyancing departments of firms the size of CELI, the oldest and the largest firm in the country, so that would be the normal practice.
To use the language of old pre-registration conveyancing, the 1967 deed would have been the root of title.
Correct, my lord, yes.
For this sale.
Absolutely, my lord. Yes, my lord, yes. And my lord is well familiar with that notion from this case, of course, and other decisions of the board, one of which I think is in the bundle. And so, my lord, lastly, if we go to the descriptions in the schedule, they confirm and are consistent with, so at the bottom of page 72, the larger parcel, 1 acre, 3 rooms and 4 perches, delineated and colored.
Sorry, which page are you on now?
I'm on the same page, my lord. 72.
72.
Yeah, I'm at the bottom of the page, my lord. I went to the description in the schedule.
So the first part is what we've been calling the larger parcel,
You've got
and
it,
the
lady.
second part is the smaller parcel.
Yeah.
You've got it, lady. Yeah. So I didn't propose to read out those two descriptions because they're there, and I think you've had a look at these already.
And that's followed through on the plan at 75, which is the slightly different black and white version of the one we've now got in colour.
Yes.
Different in the sense that somebody's written pink and green, and we can now see that reflects pink and green on the original.
Yes. And my lord, there was only one other aspect of conveyancing practice I didn't share with you, which is that under the, as my lord has called it, old law conveyancing, that's how it's referred to at home, originals of deeds are all kept
In the deeds registry.
in the deeds registry. That is in contradistinction to registered land title, where the owner is given by the registry his or her or its original certificate of title. So that's the distinction.
But I'm not quite sure where this gets you, in the sense that what you're showing us here
Yes.
is a very comparatively clear deed of conveyance
Yes.
conveying 2 areas of land.
Yes.
Now, we've got a deed of conveyance conveying only 1 area
Yes.
of land. So how does this document actually assist? I'm not quite sure I see the connection.
Well, my lord, so I was making a couple of points. One was the point I made about consistency. But to zone in on my lord's question, and I'm going to take you to it in a minute, if my lord simply thinks of, well, what was the mistake, to use the language in the case is, that the deed that we are considering in this case, that mistake is summarized in these 3 words. And the second one, forwards, and second part. Because in the deed, and I think it might be helpful for us to look at it now, rather than me doing it off the top of my head.
Sorry, just before we move away from this document, I'm looking at page 72 and just trying to understand what right-of-way was being reserved
Yes.
by this deed. And I'm sort of towards the bottom part of the page under now this deed witnesseth
Yes.
1.
Yes.
Am I right in thinking that for all purposes connected with the existing use of the remainder of the adjoining property of the vendor known as the Glen?
Yes.
The Glen is what we've been calling the adjoining property. Is that right?
No, it's much larger than that, but the
it
adjoining property is a portion of it.
Right.
Yes.
So when it says that the right-of-way is being reserved
Yes.
to allow for use of the Glen, which includes the adjoining property,
Yes.
the dominant tenement for the purposes of this right of way is what we've been calling the adjoining property.
Yes, my lord.
in effect.
Yes.
That's the.
Yes, my lord.
I just wanted to make sure.
Yes, I'm sorry. If I didn't, I had been working on the assumption that based on the previous exchanges that my lord, that was
sorry,
not something that I had to spend time
It's
on.
me being slow, but I just wanted
No, my
to
lord.
verify I had
Far from
understood what the Glen
Yes,
was.
yes, my lord.
We have incidentally now got a lovely coloured version of A4.
Have we?
Don't
So
worry
the
about it.
purpose of the 1970s was it conveyed both the larger and the smaller parcels, and it reserved to the adjoining land a right of passage over the smaller parcel.
Correct, my lady. And I go further in answer to my Lord Burrows, and that was the intention of the deed that we are considering now. In other words, but for those missing words, 3, 4, doesn't matter, that's exactly what it would have done.
Yeah.
So insofar as I have to answer the question, or rather the Court of Appeal answered for itself the question, does it meet the test of rectification? Both the case law and the commentary distill it into two elements. It says, tell us what the mistake was, and then, in other words, that should be apparent, and then it should also be apparent what the correcting version should be. My lords, I take it, I may be mistaken, I take it that's where the notion of convincing proof comes from. It really just has to be, reasonably clear. Of course, there's a whole range of cases, a spectrum of them. But my respectful submission on it, and in answer to my Lord Burrows, sort of piggybacking on what I said before the short adjournment, is that on the application of that test, and you will say whether I've distilled it accurately or not, then this was a case, if ever there was one, for rectification. My lords, although I did say that I wouldn't say anything about the law, it is perfectly plausible, as a matter of legal argument, to have construed these documents. I construed the agreement for sale, A2, A4, and the deed, and consider that the correct construction of the deed was that it conveyed both parcels of land as a basis, as an alternative basis in law for the.
Well, that's what happened in Chartbrook, isn't it?
Well, my lady, that's why I said it. It's not just because, my lady, I go further. That's what happens in cases like this. In cases like this, it's not just a Chartbrook, it's like this case.
I'm not sure we can row back quite that far.
No, my lady, well, but I'm not trying to make a factual point. I'm just simply
this
saying
is
that.
the first time you've raised the fact we can get there by interpretation alone, which is
My lord
seems to be your submission here.
Absolutely right and absolutely fair. Absolutely fair pushback on me, except I'm simply making what I regard as a legal point, unless I've misread Chartbrook and I've misread the commentary on it in particular. But I just wanted to say that and say that you can get there on the same basis, and it's understandable, my lords and my lady, a lot of the commentary is a reflection of the interplay between construction on the one hand and rectification on the other. And my Lord Burrows, your article, if I've been misled,
Helped you out with that, did it?
my lord, that's where you pushed me intellectually to make sure that I understood the point. So, my lords, that's what I wanted to say about the 67 deed. Can I just have a quick, I'm seeing the coloured copy, if there's anything I wanted to say about the coloured copy. Other than the coloured copy makes it plainer, if I may say so.
Well, it just shows that it really was pink and green, as somebody has written on it.
Correct. Now, so my lords and my lady, the judge did not consider the 67 deed. If it's an error, a small error, a big error. So let's move on. Can I invite your attention now to A2? And my lords and my lady, unless you tell me otherwise, what I propose to do is to kind of walk you through these documents and try to make not the same points that have been made already, but just some additional ones in support of our position.
Which of the many versions of A2 that we now have do you want us to?
Well, this is where I'm slightly perplexed. I have to do it on my feet. Can I start by asking you to look at electronic bundle page 22, and then I'm going to invite your attention to the the email that you've gotten as soon as I could find it. So, my lords and my lady, if you are at electronic bundle 22, a couple of small points really made plain by my learned friend when he was assisting you with the documents. The first is that there is a number to the left-hand corner, 91705. And I was deliberate about putting that number in my written case for this purpose. Secondly, it is a document signed by both parties, as it were, either side of the transaction. So there are 3 signatures, Mr. Porter, Mrs. Porter, and Mr. Stokes. Thirdly...
Sorry, can I just ask, do you know where the number 917 comes from?
Well, my answer is going to come from instructions. So my instructions are that certainly in the 1980s, surveyors had numbered sheets so that they can discern the sequence in which they had drawn plans. And so my Lord's question invites an answer to me, from me, in response to what my little friend said. He suggested that this is Mr. Strange a moment ago, that they might have been drawn up at a different time. Well, obviously they might have been, but insofar as they have the same date, it tells you what the sequence is as of that date. So that's number 1. And number 2, my Lord, consistent with my Lord's, if I can put this very respectfully, Lord Sales, my Lord's judicial instinct, which is to say that my Lord's appreciation of the document suggested that these documents were drawn as opposed to copied, in the sense of, in 2023, we think of a copy being something that is, if a machine does, but these were drawn or redrawn by Mr. Sylvester, and that, with respect, provides the explanation for what appears on the surface to be a series of slight variations. My lords and my lady have commented on the font, they've commented on the location of particular words, they've commented on the fact that some words are capitalized and others are not. So unless a surveyor was trying to be a photocopier, which is not normally the case, what the surveyor is trying to do is accurately record his or her measurements. And that's my 4th point, which is that in relation to both parcels of land, very precise measurements, not the calculation in the case of the March document, but that calculation only comes in April. But in both March and April, both A2 and A4, precise measurements that he has measured and discerned as to their direction, so it's lengths and degrees, whether it's 90 degrees, 180 degrees, or some number in between, those are to be found on all of the documents. So that when one looks at 91705 and compares it to, I'm just making sure I have the right plan. I'm so sorry, my lords and my ladies, just to make sure I have the right plan. When one compares it to I think it's 91704.
Sorry, where do we have 9?
Oh, sorry, I apologize. I am now taking you. I still want you to have E22 available to you. So, but also, can you now look at the email which contains 2 plans that you got?
Oh yes, I see.
Yes, so we see the predecessor. Which one do you want us to look at first?
Can I invite your attention? Can I ask you to look at them in numerical order? In other words, take 91704 first. I'm not certain that anything turns in it, and then I will take you to 91705, colored version. So my lords and my lady will have in mind that you have 3 documents. I've taken you to the first, which is electronic bundle number 22. I'm now taking you to 91704. And just to make the following observations. Firstly, that both parcels are shaded. I accept entirely my Lady Rose's observation that both the right-of-way and the roadway are colored, but we'll come back to that.
This case has been reduced. Okay.
Further, that in relation to the smaller parcel, it's called right-of-way, and in partial answer to my Lord Burrows, that's consistent with the 1967 deed, hence my appellation of consistency. In other words, my lord, from the perspective of the conveyancer, and I'll come to this, how the surveyors work generally, from the perspective of the conveyancer, this smaller parcel was defined, it was named, it was given not just a delineation, but it was baptized, as it were, right of way, quotation marks. And ordinarily, a surveyor also, in carrying out a commission on behalf of a client, is also going to ask for the title deed. So in this case, that's what ordinarily would have happened. I'm not seeking to give evidence on the bar table, but I'm just saying what the practice is. And then down at the bottom, we simply have Mr. Sylvester's signature. It's drawn in March of '82. It's dated the 23rd. Is it 23rd? 23rd. 23rd of March 1982. And much more importantly, or equally importantly, I should say, after the reference to March of '82 above the signature, you will see that it is drawn for Mr. Stokes. Does my lord and my lady see those words? Yeah. Good. Yeah. So that's helpful and that's important. So now, having drawn that to your attention, can we go back now to the other colored version? That's 91705, which we know has been annexed to the agreement dated the 15th of May 1982. And I would ask my lords and my lady to bear in mind my original submission about sequence, and because we'll have to come back to that when we come to the April one. And the only observations that I would want to make is just to point out, in addition to what I've already said, so it's colored pink, yes, a single parcel, but the right-of-way, I don't want to venture an opinion as to whether the road is colored. It doesn't appear so to me, but be that as it may, the right-of-way clearly is. I think that's uncontroversial, based on the quality of what we can see. And then finally, again, just to reinforce and drive home the point that I made a moment ago, it is a March 1982 plan for Mr. Stokes. So, my lords and my ladies, that's A2. And so what I say about that by way of submission, is that the detailed analysis and consideration that could have been undertaken by the learned judge in relation to this document was not undertaken. So that I say my points are cumulative with respect to the learned judge did not consider at all the 1967 deed, its terms.
Well, was the 1967 deed before her?
Yes, yes, lady, it was. And that's why it's in the record. And insofar as she considered A2, which is what we're looking at, her consideration didn't go as deep, if I could put it like that, as what has transpired here, and as necessary. That's really my point.
1967 deed?
Yeah.
None of the coloured versions of A2 were...
No. I'm not...
How is it that
I don't know...
How is it that they've been produced in a couple of hours this morning, and for all these years, no one's had them? My lady, I wasn't there at first instance. I can't answer the question. Insofar as my lady friend, Mr. Strange and Mr. Maraj, say that the coloured versions were shown to the witnesses, I have no reason to dispute that. It's not uncommon for cases to be prepared. Obviously, copies are made and photocopies are made. And when you come to
when you come to do the actual trial, you produce the colored version because it's an agreed document. And can I add that I believe in relation to A2 and A4, that's why they're called A2 and A4, because they were part of the agreed bundle. So can I follow the same sequence as my learned friend did in terms of taking to the documents? And can I invite your attention to electronic bundle, page 28? And just because this is taking up a lot of my time, can I also ask you to have available to you A4, the colored version that you have gotten in your email?
Yeah.
So, my lord, with your leave, I'm going to sort of deal with the two documents together because you've had a lot of this already, if I may. First thing, number 91713. So it's a little bit later than 91704 and 05, which are the two documents I showed you a moment ago, in terms of sequence. I don't want to try to guess anything about time from that alone, but top left-hand corner, 91713. That's my first observation. The second observation is that we know that this is the document because it comes from the registry that has been annexed to the agreement for sale, to the deed, which is dated the 18th of August, 1982. We get that from the top right-hand corner. It is not signed by the parties, but it is signed by the conveyancer. So we say that, with respect, nothing turns on the fact that it wasn't signed by the parties. There was no necessity for it to have done so. And what I mean by that is this. So this is a document drawn up by the conveyancer, drawn up by the surveyor, endorsed by the conveyancer, annexed to the deed. That deed, of which this document is a part, has been signed by the parties. If we go down to the body of the document, and we can look at both the colored version and the black and white version, the larger parcel is colored pink, the smaller parcel is colored green. The very same measurements and directions delineating the size of the parcel are present, save and except that in relation to the green parcel, the words right of way have been removed and replaced by the calculation of the area. And when I come to look at the agreement, which I will do in a minute, I will simply make the point, as I've said to my Lord Bowers, of consistency. When we come to the endorsements at the bottom, it's again signed by Mrs. Sylvester. He has, and he said this in his evidence, I believe, his witness statement, plan of two parcels of land, colored pink and green. And what he also does, he gives you the arithmetic so that the 5,340 square meters plus the 430 square meters actually totals, it's not there, but it actually totals 0.577 hectares. So again, that's not from me, that's Google. That's just a matter of arithmetic and calculation. So that he calculates or he determines what the total area of the two parcels of land equate to. And then lastly, as my lady Rose pointed out to me, of course, this document is dated the 21st of April 1982. So it precedes the next document I'm going to invite the court's attention to. Oh, I'm so sorry. There was one observation I should make about.
You were going to refer to for Mr. Stokes again, presumably.
Yes, I'm sorry. In a sense, I take that for granted. So two observations, in fact. One, it's for Mr. Stokes. I thank you, my Lord Briggs. And lastly, insofar as we're playing the palette game, the larger parcel is pink, the smaller parcel is green, and on this occasion, my lady, the road is brown. So to the extent that there were any ambiguities, we say respectfully that they were resolved by this date, i.e. the 21st of April. So that permits us to have a quick look at the agreement, and I think that's to be found on page 18 of the electronic report. And make three small points. The first is, there was...
Page 19, I think.
Well, I apologize, my lord, you're quite right. Page 18 is just the exhibit page. Page 19, so to make three small points. The first, of course, is the fact that there was a suggestion advanced by, in the pleaded case, and that suggested that Mr. Stokes, a businessman, had not read this document. Right? So there was a kind of faint plea of non-as factum, or whatever, however it's to be properly put. There's no such finding to that effect by the learned judge at all as to whether he did or not. So again, on my theme of cumulative errors, that's yet another one. So now we can look at the actual document.
What you mean there was an error by the judge in not finding?
The judge had to say something about it, and she said nothing about it. That's my only point, my lady. She didn't say that she accepted it. She didn't say she rejected it. She didn't even, as far as I can recall, and I didn't hear my friend say anything about it this morning, at the relevant paragraphs of her analysis, she doesn't grapple with it. So I'm not going to take you back.
I'm sorry, I'm just slightly perplexed by what you're saying. Now, surely the judge proceeded on the basis that this had all the appearances of being a properly signed agreement.
Absolutely, my lord.
So how is it a material error, or indeed an error at all? With a non-est factor?
Insofar as the point was argued and pleaded and submissions were made, it just wasn't dealt with at all by her.
But she didn't need to.
Yes, and that's my point.
She's making an implicit finding in your favour.
Absolutely, my lord. So I accept that.
All right.
Yes.
Well, it was the defendant's case that the mistake, what they said was the mistake in the agreement, went unnoticed because Mr. Stokes didn't read it.
Yes.
So it was material which, if she had found in their favour, would have assisted their case.
Yes.
Yeah, it wasn't completely irrelevant.
Yes. And the flip side, not having made such a finding, she's to be taken to have rejected it. And as my Lord says, pointed out to me a moment ago, therefore the agreement for sale was binding and effective for all purposes. So if we could just come to some of the detail, and I will take this, if I can, slightly more quickly. So both parcels of land are explicitly identified at paragraph 1. That is to say, the agreement tells you what Mr. Stokes will sell and what the Porters will buy. We are concerned, of course, with the 430 square meter parcel. So that's entirely consistent with the A4 being dated April 1982 being available and being known. There is a reference, of course, in the body of the document thereafter to the earlier plan, A2, and the purchase price, as my Lady Rose pointed out, of $180,000. And my lords and my lady would have seen in my written case where I drew attention to the fact that as far as the purchase price is concerned, because of the cordial and warm relationship between the parties, Mr. Porter had in fact offered more. He had offered $250,000, and Mr. Stokes Senior, Dada, declined and said that's too much because of our relationship, and said give me $180. And they went off and secured their financing for that. Paragraph 3, completion is within 90 days. And again, Google tells me that 90 days from the 15th of May is the 15th of August, which is a Sunday. And we put this in our written case. So there could not have been completion, well, ordinarily. Some lawyers do work on the Sunday. But ordinarily, there would not have been completion on a non-working day. Over the page, paragraph 5, there's a reference to marketable title. And so I wouldn't say anything about that. My Lord Briggs and I have had an exchange about title deeds and old law and so on. And then paragraph 6 is important. My learned friend didn't make any comment about it, but this is important because, or helpful, relevant, because this expressly provides that should the transaction not be completed within the time fixed, then by virtue of, that is by virtue of any default of the purchasers, then the vendor shall be at liberty to rescind this agreement and forfeit the deposit of $18,000. So that's what the agreement provided for would happen at the behest of either of the innocent party, if I could put it like that. And that's 6A and 6B. So it is signed by all three parties, and it is witnessed by Mr. Walter Monceau. I'm not going to take you to the witness statement that confirms that. Mr. Penishuk, who is his stepson, confirms that's his full name, and he is a signature to a witness to the agreement. In addition to that, that witness statement also confirms that the Monceaus were neighbors. They lived at the property that is currently occupied by Mr. Ramachan, and again, that's all part of the record.
Sorry, what was the point you were making about Clause 6?
Clause 6 was that simply that it provided for what should happen in the event that there wasn't completion on time, but neither party exercised that option.
Yeah.
Is the point I was making.
Right.
Your point is the agreement didn't just expire by a fluxion of time.
Yes,
Time completion was of the essence.
correct.
Yeah.
So can I invite your attention to the deed now? And that's to be found in the electronic bundle, page 24. So my lords and my lady will see the description of the parties, company director, his wife, Mr. Stokes is a proprietor. So that's all in that recital. And then just to reprise my response to my Lord Burrows, in the second and third lines, beginning with the words described in the first part, my lords will see ... So something happened there. There was a change on what we say.
24.
It's first part of, isn't it? You
Yeah.
say the mistake is first part of.
No, I say and the second part is the mistake.
Yeah.
And the second part. So that those words should have read, and this was the submission that was accepted by the Court of Appeal, that the missing words were and the second part. So it could be either first part, and you could insert the words and the second, or after the word part and the second of the schedule.
Or you could just say in the schedule.
Yes, absolutely, or delete the words,
Yeah.
which is what, well, I'm not a conveyancer, so I won't say what I would have done.
So you're saying that the ... there
Is
wrongly excluded a reference to the second
Yes.
part if the 1967 deed was being used as a template?
That's one. Yes, milady. If the 1967 deed was being used as the template, 1, 2, and the deed was pursuant to the agreement for sale, which it clearly was, and the agreement for sale makes it unequivocally clear as to 2 parcels of land to be sold, both of which are measured, the last of which was measured as 430. And when we come to look at, because that's what I want to do, I want to look at the schedule next, which is at the bottom of the document, and then come back to the reservations as to the right of way, just to make good that point. So if I can do that, because I'm really on what should have been in the schedules, you will see, if we go to...
So can I just be clear? So if the words and the second part
Yes,
had been there,
yes,
that's the end of the
we
story.
wouldn't be here.
Or if the words first part of had not been there.
We would not be here.
Yeah.
Yes.
Yeah.
So all I say about that.
Except there's then three part. The problem with that is that there's also the drainage.
Part, isn't there?
No.
Yeah.
Well,
Yes.
my lord. Because there's no, respectfully, there isn't a problem, but I'm happy to, my lord, to
Well-
be testing me.
Yeah, but that isn't land, so that's not a problem.
Yeah, it's
No,
not,
my lord.
it's not freehold hereditaments and premises. So.
Yes. Ben, my lord, I want you to ask me the question, but I'm going to say it anyways. Please do.
I would have thought that the simplest submission is if one adds and the second part, end of story.
Yes.
That's my only.
But someone has deliberately taken those words out. That's the problem.
Yes, well, my lady, all of when we are writing documents and we put in words and we take them out, each of those actions is intentional. The real distinction is between whether they are mistaken, the intentional. In other words, have I made a mistake or have I not made a mistake? And so that my case is, and consistent with the authorities, as I've already submitted, there has to be a clear mistake, and fixing the mistake also has to be clear.
And you say if you make that correction, then everything falls perfectly into place.
My lord has got it. I'm sorry for not making the submission as simple as I could have, but my lords have got what the simple answer is. So, my lords, I don't want to take you to all of the schedules, but I do want to spend some time on the second part. So, can you skip over a page, go to page 26. And really, three observations. First of all, it is specifically identified, i.e., the second part is set out in the schedule. What is set out in that schedule is the parcel of land is delineated, described, and identified. Delineated as in measured, described as in located, and identified as in colored green.
So, and just a small point. Interestingly, it says being portion of the Glen.
Absolutely.
I wonder if that's another
Yes.
indication that the conveyancer has the 1967 conveyance.
My lord is ahead of me. So that is, I accept that. That's absolutely correct. I rely on that. And of course, the very same observation can be made in relation to the first part. So after the measurement, although I said I wouldn't go to it, but I guess I have to, after 5340.3, being portion of a larger parcel of land comprising 3 acres, 1 rood, and something purchased, known as the Glen.
Yeah.
So that is location, where, and identification, the two go together. So what we say, just pausing there in relation to the second part, is that the detailed description given to the second part is entirely consistent, and I go further, only consistent with an intention on the parties to convey. While I have your attention respectfully, can I invite your attention to the third part, which is the drainage rights that Mr. Porter recalled were to be done. We make no issue of it. The plans that we have already looked at, and this is the one thing that I did not drive home when I was inviting your attention to A4, whether colored or not, there is no issue that these drainage rights and the drain location is identified in A4. So can I now go back to the other?
There, the said lands really does mean only the first part, because it's the drainage is only in relation to the main part.
That's correct. That is correct. The drainage begins at the western end of the smaller parcel. I don't know
Or
if
the
that's helpful.
eastern boundary, as it says here.
Yes, you're
of
right.
the
I agree.
larger parcel.
Yes, I entirely agree. So can I just take you back now to the other cumulative source of discerning objectively the party's intention, which has to do with page 24 and the reference to rights of way, which I say with submission number 1, and submission number 2 is nothing that, with the great respect to my little friend, that was said by him this morning constitutes a coherent attack on that analysis. That's to be found in paragraph 76 to 82 or thereabouts, where they distill. So just going to the documentary evidence and picking it up after the reference to the deed registration number 9024, that's about line 6 into the first recital, subject, however, to right of passage, pausing there, that language sounds familiar, open brackets, hereinafter called the right of way. So just stopping there. So what this conveyancer is doing, just like his or her predecessor in 1967, is engaging in a little bit of definition. Right of passage, hereinafter called the right of way, over and along the parcel or strip of land described in the second part of the schedule, reserved 2. And I don't need to take you to the rest of it. Next recital, and whereas the vendor has a, oh, sorry, I should just, we have discussed it before, you have had it discussed with Mr. Barrage. In the second part of the schedule, here to reserve to Janet Stanhope Lovell. So as my Lord Briggs observed, it's an attempt to recreate what was similar to the reservation.
In relation to which the adjoining land is the dominant tenement.
Precisely, my Lord. Yeah. So just keep going to the very next recital.
Is there anything in the reference to the covenant in clause 2?
My Lord, I did not look at it.
Okay.
So that's the short answer. I mean, we could look at it together if you like, but I did not look at that.
Starting yet further.
Yeah. So second reference, that's the first reference to right of way. Here comes the second reference. It's in the next recital. The vendor has agreed, say to them with the lands together with the privileges, benefit, blah, 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 subject to the right of way. So that's reinforcing. And then there is an exception, accepting and reserving unto the vendor the rights of drainage. So that's, again, consistent with what Mr. Porter's evidence set out in the third part of the schedule. So that's the second reference. And the third and final reference to the right of way is in the operative part of the deed, which is where we'd expect it to be at the very end of the first subparagraph, beginning with the words, now this deed witnesses, at sub Roman numeral 1, very last words, the property is conveyed to the parties in fee simple as joint tenants, subject to the right of way. So that's a reservation of the right of way to the vendor. So my respectful submission on this is as follows. It's not just that the document is entirely consistent with the parties' intention to convey both parcels, i.e. the cumulative effect of the mistake that I've identified and the express reservation to the vendor, that's point number 1. Secondly, that's in the context, as my lords and my lady were discussing just before the short adjournment, in the context of the parties being alive to rights to pass and repass acquired by prescription. So what this was, not just an attempt, it was a successful attempt to expressly reserve those rights. It wasn't simply a question of, well, I've got these rights by prescription and therefore nothing, it doesn't really matter. That's not it at all. And that was the premise. I'm not asking my lords and my ladies to turn it up now, but if you go to the very first 4 or 5 pages of the transcript of the Court of Appeal, the Court of Appeal expressly discusses the case and debates it on the basis that, well, this is not about whether somebody has a right of way or not by way of prescription. Because irrespective, as my Lady Rose pointed out before the short adjournment, irrespective of which way we decide the case, that right of way to either party is present on that basis, on that common law basis or implied basis. It doesn't really matter. But that this case, in a sense, was, these are my words, they may not be accurate, belt and braces. This was, again, the conveyancer being specific and express, and that desire to be express and specific only makes sense in the context of the parties' plural S apostrophe intention to convey both
But
Parcel.
as at 1982,
Yes.
Mr. Stokes didn't yet own the adjoining land.
No.
I don't think.
No.
So it was.
Oh, I'm sorry. No, I think he did.
He did.
Yes, he did.
My recollection is, was there a deed in 1970?
The adjoining land.
Yes. Yes.
He did.
Yes. Sorry, my lady, I got the
Right.
sequence wrong.
Okay, so then the point against you is that at the bottom of 24, it's not accurate to say that he owns the. It's not accurate to say that he owns the first part, the larger parcel, subject to a right-of-way for the benefit of the adjoining land. It's rather mixed up because the right-of-way was always over the second, the smaller part. I don't think there was ever a right-of-way for the benefit of the adjoining land over the larger part.
No, my lady, so, sorry, I think we're at cross purposes. If you could tell me what words you're reading, and then I will tell you what
At the bottom of page 24.
So, subject, however, to the right of passage, hereinafter called the right of way, over and along the parcel or strip of land described in the second part. So if we stop there and ask what's the second part, that's the smaller parcel. It's not the adjoining parcel, my lady.
Yes, but then he's saying it's reserved to Janet Stanhope Lovell, and that is for the benefit of the adjoining land.
But my lady, I'm respectfully drawing a distinction between where the right of way passes and doesn't pass, on the one hand, which is over the parcel that measures 430 square meters, and the parcel for which it is the benefit of. That's different.
Right, but it's not right to say that he owns the premises described in the first part, which is the larger parcel, subject to a right of passage. Well, it's an odd way to express it.
But I think Councill's point is that it all falls into place if you cross out, if you add the words and the second part of the schedule.
Yes.
In other words, it only makes sense if you add the second part of the schedule, because then he is reciting himself as owner of land, which is in fact subject to that right of way. I think that's your point, isn't it?
Yes, my lord, you've got it. But my lady, in any event, what we say is that it's common ground to this extent that there were, if I can use neutral language, problems with this deed. So that insofar as what the porters were concerned to do, which is to clarify what they understood in the documentation to ensure that it reflected the party's intention, their claim for rectification is soundly based on the A, analysis of the documents, and B, its proper application to proper application of the principles of law. So we say that here again, the learned judge did not engage in this analysis. So this is a further, I think it's the fourth cumulative point of the right-of-way points, I think, that, let me just have a quick look, make sure I don't overstate my case. So we say with respect that when you come to consider what the learned judge analyzed in relation to this language in the deed, we say that the learned judge did not carry out the analysis that I have commended to the board, and that was in fact carried out by the Court of Appeal. So pulling some of the threads together by way of the documentary analysis, we say it is important that the Court of Appeal did, but the judge did not consider the fact that on both A4, which is the April survey plan, as well as the deed, that it accurately recorded the reference to drainage rights, which had she done so, would have led her to a different assessment of Mr. Porter's evidence, because what he had to say about drainage rights was wrong as to timing, but right as to content. And then lastly, we say that the deed, but for those omitted words, whether putting it in the slightly overly complex way that I did or the simple way that my Lord Briggs did, but for those missing words, but for the mistake of those missing words, all of these analyses taken together, which is what the learned judge ought to have undertaken but did not, reflects convincing proof of the party's intention.
And do you rely on the expression the said lands?
Yes, absolutely, my Lord.
The plural.
The plural, I do. And then lastly, although my little friend makes a complaint about it, I think with respect, it is important and helpful for my lords to know that at the same time as the parties executed the deed of conveyance, the Porters also executed a deed of mortgage, as my Lord Kitchen pointed out, of both parcels of land. That deed of mortgage is in the papers, and the financing arrangements, contrary to my little friend's submission to you this morning, were the subject of evidence and cross-examination. In other words, how else could the court below have had anything to say about financing and financing arrangements? And how else could the High Court judge have had anything to say about something being an act of deception? There was an express finding on her part, we say a wrong finding and an unjustified finding, and a finding without foundation, and the Court of Appeal expressly overturned that finding. The whole...
Can you just assist us with some references? So
yes.
The deed of mortgage is...
The deed of mortgage is... my Lord, I apologize. I was racing ahead. You will find that at electronic bundle, page 647
and then
to 656. And
you said this was the subject of evidence and cross-examination. Where are the references for that?
Yes.
Sorry.
No, not at all, my Lord. My Lord, can I... Yes, cross-examination of financing arrangements. It's in the 700s. If I just pick it up very quickly. You will pick it up at page 739. This is the cross-examination, I believe, of Mr. Stokes. Sorry, Mr. Stokes by Mr. Garcia.
And with the Porters.
And the Porters. I think the only... Sorry, my Lord, I don't want to try to do this from memory.
This is the cross-examination of Mr. Stokes, I think.
Yes, that's right, my lady. That's what I said a moment ago. The only reference that there was, I'm going to try to find it, of Mr. Porter in relation to the mortgage was that he accepted that he signed the mortgage. So,
I mean, the Porters took a mortgage over both pieces of land.
yes, they did.
To secure the transfer of the land to them and the payment of the purchase price.
Yeah.
Correct.
But it's being put to Mr. Stokes that he connived in the deception of the financial institution. And he says, well, it may have been dishonest, but it wasn't our dishonesty or my father's dishonesty, if you look at 740. But you're saying it wasn't also put to the Porters that they had more directly.
Yes, that's correct. So Mr. Porter says at page 720, in answer to the question 720, in that file, did you sign anything? Answer, probably the deed of conveyance, and I would have signed the transfer to the mortgage company. So my only point, my small point in answer to my friend's complaint as to whether this was mentioned was that it was mentioned. And it was an underlying element in the case. That's all. Of course, apart from the submissions that I've already made, which is to say that it was never put to Mr. Porter that he had.
But this was not relied on as supporting the fact that the conveyance should have been for two parcels. What Mr. Maharaj was trying to bat back was your apparent reliance on the fact that they took out a mortgage over both parcels as support for the fact that everybody thought they were getting both parcels, which is a different point from whether there was a deception.
Yes, my lady, I agree it's a different point, but no, I don't accept that that this document was before the court, it was executed at the same time, and those are the facts. So that the suggestion that it wasn't relied upon, I don't accept. I would accept that, not that, if it were put to me that not a lot was made of it, of course I accept that.
But it was relied on before the judge, was it, specifically?
No, not in that way. It was not. It was caught up in the more of allegations of improper conduct. But the underlying premise of it, in other words, the way that Mr. Garcia's cross-examination proceeded to Mr. Stokes was, well, what you seem to be saying is that if your story is correct and they were to leave the financing arrangements in place, because that was the argument, then that's dishonest. So my point about that, it was the underlying premise of that question was that there was a mortgage of both parcels of land. Otherwise, it could not have been dishonest. So to that extent, I say, in answer to my Lady Rose and to my Lord Kitchen, yes, it was relied upon indirectly in that sense. Did someone...
Can I ask, did the Porters give evidence in chief or in their witness statements about the financing arrangement?
They gave evidence... This case proceeded by evidence on witness statements. There was some amplification. My lords, my recollection, I'll double check, my recollection is that there was no detail about it. I don't recall there being some detail about it, other than...
So nothing said in their witness statements about the financing arrangements?
Can I just check, my lord? Just to be careful and not give an inaccurate answer.
One might have thought this is pretty fundamental stuff, Mr. Party's intentions.
Could my lord put that
into pretty fundamental evidence, really?
My lord, we've all been involved in cases where, had we done it, we would have done it differently. Okay, so, my lord, I have to say yes. I mean, with the benefit of hindsight, you know, right. I'm not going to say what I would have asked, but I'm going to answer my lord's question.
At all events, if you can assist us, either just to say no, there was nothing, or there was something, and tell us where we find it.
Yes. The witness statement is to be found at page 596, and I'm going to just, my lord, not to rely on memory, just search your word mortgage and see if it's there. My Lord, paragraph 9. I consulted my wife. Is my Lord with me? Page 598. I consulted my wife and considered our financing position and made some inquiries of my insurance broker at Barbados Mutual Life Insurance. My insurance company kept with the figure I felt my wife and I could manage. So that's one. And then there's that reference to the change in the price that I've referred to already. I won't repeat any of that. My Lord, I think that's the only reference that I can find.
The real reference comes in the defendant's evidence about what your clients said about amending the contract.
Yes,
Yes.
for that purpose, which is what I was trying, perhaps clumsily, to say to my Lady Rose a moment ago. My point about that is that it was not an issue. It's not a disputed issue that the parties sought financing. That was the basis upon which they made their proposal, and that those details were known, according to Mr. Stokes, on his version of US. My Lords, I'm not sure how I'm doing for time.
You've got about 9 minutes.
9 minutes.
Well, no, you've got a bit more than that because your opponents bit into their reply time by about 10 minutes.
And does my 9 minutes count from 2:11?
You've got nearly 20. You've got until 22 at any rate.
Applies, my Lord. Lord, I want to try to pull some threads together for my purposes and say the following. So our respectful submission is that the board should dismiss the appeal for the following reasons. A, the Court of Appeal got the objective test right. And I'm not going to repeat anything I said before the short adjournment. They got the objective test as to the law right. As a matter of law, legal principles, so that any complaint in my friend's written case about them getting the law wrong goes, we say no distance at all. B, we say respectfully that their analysis demonstrates the correct application of the objective test. Which is to say, you start from a prior concluded agreement, i.e. the agreement dated the 15th of May, 1982, and you go forward in your analysis, which is what I've taken the board through a moment ago. And we say, thirdly, that on its own, the provisions in the documents, plural, i.e. the agreement for sale of the 15th of May, 1982, and the deed of conveyance of the 18th of August, 1982, those documents alone in relation to the reservation of the right of way to Stokes as vendor are entirely consistent with and are convincing proof of the party's intention. C, we say that any reservations about that are resolved by a close analysis of the recital of the deed of conveyance and the missing words or the wrongly inserted words, it does not matter which, respectfully. And D, we say that the only evidence, direct evidence corroborating that documentary analysis and inference came from Charles Porter, Mr. Walter Stokes Sr. Dada having departed this life. And that E, any reliance upon alleged admissions or utterances reported by others, whether it was Mr. Rameshand or Mr. Brown or Mr. Panashak, don't take the case any further for two reasons. One is that they are of an entirely general nature. He didn't intend to sell and that sort of thing. They don't shed any light whatsoever on the documents. And further to that, they come after the fact, and in any event, were never put to Mr. Porter. And to come to findings of fact on that basis is entirely unsatisfactory if you haven't had a chance to meet the case, if it hasn't been put to you. Because it not having been put, the judge didn't have the advantage of assessing demeanor when those issues were being put, because they weren't put. And then finally, we say that the finding as to fraud and deception not pleaded, grave, this board doesn't need any help from me as to what the appropriate standard should be. But if ever there was a requirement for convincing proof before one came to a finding of fraud, which is what the cases say, I mean, it doesn't use those words, but that's exactly what they mean, then that didn't happen in this case. Wasn't pleaded and it wasn't put. So that when you take the documentary evidence together with the testimonial evidence, and thirdly, bear in mind the lapse of time, and come to interrogate the findings of the learned judge as to whether they withstand serious scrutiny, we say that with great respect that the Court of Appeal, A, conducted that analysis of the underlying documents, B, came to the right inferences as to what it told them about intention, C, tested those inferences against the applicable oral testimonial evidence, and D, concluded rightly, and we say in a manner which is, with one exception, and I'll come to the exception in a moment, not capable of, great respect, legitimate criticism by the board. And the one exception, as my Lady Rose knows, is April for August. That was how I put it in my written case, and I think I made it clear that I'm not pursuing any of that.
Sorry.
I apologize. I'm sorry. I'm talking in code, my Lord Krypton. Yes, forgive me, my Lord. I was simply accepting that I do not pursue the argument that the A4 survey plan must have been drawn up in August. I don't pursue that. And to the extent that the Court of Appeal so found, with great respect, not only does it make no difference to my case, but as my Lady Rose anticipates, a finding that it was drawn up in April of 1982 strengthens the respondent's case, not weakens it.
And sorry, where did the Court of Appeal find that it was drawn up in August?
They did that, I think it's around paragraph 85.
Paragraph 85.2.
85.2, yes.
And that was bound up with their acceptance that your client's explanation for the delay in completion was the correct one.
Yes. Yes, my lady.
Yes, thank you.
Do you want to say anything about the other point which was strongly relied upon by Mr. Maharaj, namely them treating as not contentious the proposition that both parcels were being sold at the time of the contract.
Yes, what I was not able to discern from Mr. Marage's oral submissions or the written case was the basis for that with respect to assertion. At that time, even, let me put it differently, even on his case, there is a post-contract change. At the time of the agreement is clear. Or put it differently, any ambiguity that might have occurred in March when A2 came into being was resolved by April when A4 came into being and put to rest by the 15th of May 1982. So that's my first answer. The second answer is, as the judge correctly found, that agreement was professionally drawn. That's the language in the cases. That was not a sort of informal agreement that one might get from a real estate agent, for instance. It clearly had reflected legal language and, legal training, if I could put it like that. And she was correct, and that was not an issue between the parties that Monsieur Selle, or at least one of the conveyances there, had drawn the agreement, or at least, and we can tell that from the fact that it's witnessed by the parties and so on.
So now that you accept that A4 was in fact drawn up in April and so pre-existed the May agreement, then the puzzle is why it was not that one rather than A2 that was attached to the agreement, but that's just one of the many puzzles, you would say, raised by this.
It's a puzzle which I certainly don't have the resources or the ability to resolve, I would say respectfully. But Milady is right, it is a puzzle, but it is just one of the many that attends ordinary human activity.
Why do you say an April date strengthens your case? Is it because it was prepared for Mr. Stokes?
A was prepared for Mr. Stokes, but that's really sort of en passant. B, because really it speaks to the two parcels of land. That's really, and it measures them.
The point, as I understood it, was that the A4 does coincide with the terms of the written agreement.
Yes.
Because of the precision of the area of the smaller parcel.
Yes, my lord. So that's what I was trying to say in my rather clumsy way when I said it measures the parcel of land, it specifies it, and therefore I'm back to how I put it to my Lord Burrows about consistency. So it is as far as the measurement is concerned, it's a consistent document, consistent. If I can steal Lord Sales's language, these two pieces of external evidence, that's the thing I'm stealing, my lord. In other words, external to the deed, is how my lord put it before the break. The contract and the survey plan are pieces of external evidence, external to the deed, and when one draws those threads together, trying to resolve the puzzle, as my Lady Rose puts it, we say that any threshold of convincing proof was properly regarded as being overcome by the Court of Appeal, and that the learned judge was in error to come to a different conclusion.
So at the time of the May agreement, there was in existence the plan A4, which was consistent with that agreement in conveying two parcels.
Yes, my lady.
And you would say a document which shows shows two colours in the larger and smaller parcels.
Yes, my lord, that is absolutely right. I would say that all of them are very helpful, and I want to thank my friends for the trouble that they and their team have taken to provide the board with those colour copies, entirely consistent with our case. My lords, I don't know where I am in time, but I think that's...
all your time.
No, I know. But, unless my lords and my lady have a question for me, that's as helpful as I can be.
Thank you very much.
Not at all. Elaine.
Mr. Mara.
Much obliged. Mr. Benjamin said of Plan A4 that the ambiguities were resolved by the date of the Plan A4. He pointed out that Plan A4 was made for Mr. Stokes, but the evidence was that it was made at Mr. Porter's request, paragraph 19 at page 601. Is it 601? Yeah. And that Mr. Walter Stokes did not see A4 until the execution of the deed. And as the judge found, Walter Stokes was not shown this before the agreement for sale. What is significant about A4 is that if heavy reliance is placed on A4, and A4 was prepared before the agreement for sale, identifying 2 parcels of land, why A4 was not signed by both parties, but A2 was signed by both parties, which was the first plan. Then, Mr. Benjamin, if I can deal with the objective test. For the objective test, the parties have to be purporting to give effect to a prior binding contract. That does not address the judge's finding that the parties in this case were not purporting to give effect to the written agreement. As Lord Boris has suggested, the agreement for sale, it could have been mistaken. There could have been a mistake. But in this case, the parties agreed not to be bound on the appellant's case. On the appellant's case, Walter Stokes asked the respondents to rescind the contract. The porter said that they were not going to rescind. Let's not rescind. We'll just agree not to perform the written agreement. In layman's language, that is how they believed it was. That, in law, gives rise to an estoppel. The parties agreed not to be bound. They would be held to that agreement and be stopped from insisting on the performance of the written agreement for sale. And the evidence before the court was that Walter Stokes did not have legal advice, did not have independent legal advice. In respect of the point of deception raised, the suggestion was that it was unfair to make a finding of deception. If the judge went too far, that finding was not essential to her conclusions. The point is that the judge formed a clear impression of Mr. Porter. She didn't believe him. And prior to the finding about deception, she made a finding of the first plan describing 1 parcel as representing what the true parties' agreement was. And that is why Walter Stokes signed the agreement. That is why Walter Stokes signed the plan. That finding is supported by common ground that the parties agreed to instruct Mr. Sylvester to produce a plan depicting exactly the land to be sold. They all attended the survey and pointed out the land, and as a result, Mr. Sylvester produced a plan of 1 parcel of land. In dealing with the color of the plans, we submit that whatever the exact color of the plan was described as, what is certain, the plan, A2, was a plan of 1 parcel. A4 is a plan of 2 parcels. And the plan of 1 parcel was a direct result of the party's instructions to Mr. Sylvester. And the evidence was that Mr. Walter Stokes said he signed the plan because it was a plan of 1 parcel. Mr. Benjamin has made a point about in relation to other witnesses and at paragraph 431, paragraph 88, things were not put to Mr. Porter and referred to Mr. Ramichan's account and etc. Mr. Ramichan's account was pleaded in detail by the appellant at page 54, in particular subparagraph C. In their pleaded reply, the respondents denied it, but the first respondent did not address those allegations in giving evidence, anything in his witness statement, nor did Mr. Sylvester. If they had declined to give evidence on this point, there is no reason why the appellant was bound to cross-examine on it. As for Mr. Peshnik's evidence, it was open to the first respondent to amplify his evidence in chief to address any allegations raised against him by Mr. Peshnik, but he did not do so because the witness statements were exchanged. And when the witness goes in the box, they have a chance to amplify. In those circumstances, again, there was no reason why the appellant was bound to cross-examine. Mr. Benjamin's point, he said all that is missing from the deed is 3 words. Instead of first part, it should say first and second parts. And it is very significant that that gives rise also to my alternative explanation, which I gave before. Maybe the first draft of the deed did say first and second parts, because that is what the attorneys taught them that they were doing until Mr. Porter was corrected by Mr. Walter Stokes. And I wouldn't say careless conveyancer, but a conveyancer which was not looking at all the facts, altered the description of what was being conveyed without making consequential amendments to the right-of-way. But it is very significant that at page 24 of the first page of the deed of conveyance, after premises described in the first part, there is something missing, and that maybe they had a first and second part of the schedule. What we do know is that the deed, in clear and unambiguous terms, described the first part as the said lands. And that is really strong in my respectful submission. With respect to the mortgage documents, what is being relied upon in the submissions of my learned friend is saying that the learned judge failed to consider the mortgage deeds in order to show that what was mortgaged was 2 parcels of land. That was not an issue. Those evidence was not put before the court. Yes, it was disclosed, but the law is clear. Mere disclosing a document is not evidence before the court. So our submission on that, it was not put in evidence, it was not exhibited, no issue was raised on it, it was not pleaded, no arguments were made based on the mortgage to the judge or to the Court of Appeal. They did not rely on it at all until now. And this is a new point, not taken before, and the learned judge cannot be fairly criticized for not taking it into account. If it had been taken at the trial, the evidence or the course of the trial might have been different. The appellant was not a party to the mortgage and so could not give an account of its creation or execution. To rely on the mortgage would have placed more focus on disclosure and the absence of the conveyancing file, which was remarked upon by the judge. In the circumstances, the execution of the mortgage, since it was not relied upon, and if it was relied upon, the appellant might have sought disclosure of the conveyancing file instead of being content with the respondent's failure to disclose it. Of course, there would be cross-examination. So there's prejudice to the appellant if the mortgage documents have to be considered. So the terms of the mortgage, however, do not compel the conclusion that Walter Stokes must have intended to sell 2 parts of land. The mortgage deed cannot prove his intention. the mortgagees would be able to shine a light on what the parties had in mind, but not as between Mr. Stokes. And the judge cannot be said to have gone wrong in failing to consider it. There is a case that I referred to in the supplemental bundle, which I just want to, that is a case of Jones, Nicholas Jones and MBNA International Bank. It's a decision of a decision of the Court of Appeal, and I just want to refer the board to paragraph 38 of that judgment.
38.
38.
Is this a supplementary bundle?
Yes, yes, my lord. It's page 11 of the PDF.
It's a bundle with 49 pages.
11 of 49.
All joint supplemental bundle of authority.
Page 11 of 49 of the PDF bundle.
Yeah.
Yeah. Have you got it, my lord? Paragraph 38. It is not in dispute that a withdrawal, concession, or take a point not argued in the lower court requires the leave of this court. In general, the court expects each party to advance its whole case at the trial. In the interest of fairness to the other party, this court should be so to allow new points which were available to be taken at the trial but were not taken to be advanced for the first time in this court. That consideration is the weightier if further evidence might have been adduced at the trial had the point been taken then, or if the decision on the point requires an evaluation of all the evidence and could be affected by the impression which the trial judge received from seeing and hearing the witnesses. Indeed, it is hard to see how, in those circumstances obtained, this court, having regard to the overriding objective of dealing with cases justly, could allow that new point to be taken.
And what paragraph was that?
Paragraph 38, my lord.
38, thank you.
My lord, in closing, when I listened to my learned friend, I thought that we were really dealing with an interpretation of a contract case. This is a claim for rectification. And really what the issue was before the court was what was the true agreement between the parties. Yes, documents have to be looked at, but looking at the 1967 deed, and may I point out that in the recital of the right-of-way on the face of the deed, whether it was the first parcel or the second parcel, there was no right-of-way in 1982.
Can I just check?
90 days from the...
There was a
sorry.
right-of-way.
Sorry.
There was a right-of-way over the smaller parcel, which Mr. Stokes granted a right-of-way to Miss Stanhope Lovell on the adjoining land, wasn't there?
But
It would have been extinguished in
No, I asked that
1970
question.
by the 1970 deed.
Right.
Yes, because he acquired both the dominant and the servient tenement.
All right.
There's one minor correction, 90 days from the 15th of May, according to my count. Is the 13th of August.
That's what? That's not a Sunday.
That's a Friday.
Well, now we're trouble.
Google gives you a different answer from...
Unless I can assist your lordship, ladyship.
just one question. Have I correctly understood it that at no stage did Mr. Stokes have his own lawyer looking at the transaction?
No,
Or am I wrong about that?
he did not. He did not.
Conveyancing was done, as I understand it, as one would expect, by the buyer's lawyers.
By the buyers.
That's how it's done. The contract's
Yeah.
often prepared
Mrs.
by the
J.D.
vendor,
Salient
the conveyance
acted-
is prepared by the purchaser.
He acted on behalf of both of them.
Right, yeah.
In effect, it seems from the evidence that Mr. Stokes had confidence on the Porters. They had a very good relationship. And when you look at the evidence, when they agreed for the oral agreement for the survey to be done, he allowed Mr. Porter to get a lawyer to prepare the agreement and he would sign the agreement based on the survey that they did, and that's how it worked.
Okay.
Much obliged.
Well, thank you very much. The board is most grateful to Council for their vigorous and sometimes entertaining submissions, and to the teams behind them who've no doubt done a great deal of work in preparing, and in particular to the unknown photocopier out in Trinidad who's caused this supply of coloured plans to arrive within moments of being asked for. We are really most grateful for that help. Meanwhile, the board will take time to reserve its judgment.